Yep.
You're like, I'm not answering that. Turn off my phone. Is it 7 o'clock?
Yeah.
All right. And is, you ready to go? Welcome, everyone, to what is January 8th, 2024 Planning Board meeting. Please note this meeting is being made available to the public through an audio recording, which will be used to ensure an accurate record of proceedings produced in the minutes of the meeting. All comments made in open session will be recorded. Also, board member James Nunes is participating via remote participation in accordance with requirements of 940 CMR 29.10 via speakerphone due to his geographic distance. All votes during this meeting will be made via roll call. Okay, our first item up for business this evening is a discussion about Article 12, Town Bylaw with Caroline Murphy tonight, yes?
Carolyn Murray.
Carolyn Murray, sorry.
That's okay.
I looked up, I didn't finish reading, I'm
That's
sorry.
okay. I was going to say, my whole life I get mailed for Carolyn Murphy, so it's fine. It's okay. So, good evening, members of the board. I'm also here tonight with my colleague, Haley Reifus, and I assume that the reason for the discussion is really to look at the Attorney General's, some of the cautions from the Attorney General's letter based on the MBTA communities a bylaw that was adopted at the annual town meeting, and what actions, if any, are required. And I guess the simple, would you like me to just start? Or, Madam Chair, did the board have, okay, great.
Because we weren't sure of exactly what wording we needed to change, and we figured.
Fair enough.
Rather than trying to come directly to you, tell us what verbiage we need to change and.
Or if you need to do anything at all.
Correct.
That's where I was going to start, so thank you for that. The short answer is no, you don't have to do anything, because your bylaw has been approved. You know, you worked with Horsley Witten. I know you also worked with Amy Questle of my office. I talked with Amy prior to coming here tonight, and we all agreed, no, you don't really have to do anything. It was a little unusual that the Attorney General took so much interest in this particular bylaw, but in all fairness, you were one of the first communities to adopt the substantive bylaw under the MBTA communities, so I think they're wading into this a little bit carefully. But if you were inclined to think about what are some of the things that the Attorney General cautioned about, one was, as you know, you've allowed multifamily just in the industrial A and B zones. And we look at all of the other uses that are also allowed in the A and B zones, like adult entertainment or, you know, marijuana, or as the Attorney General points out, despite what the bylaw says, you know, a landfill or a transfer station could be cited in any of those zoning districts. Quite frankly, Amy and I kind of chuckled at that comment from the AG because we started rattling off a number of communities that we're all aware of and even live in, where there are single-family houses and neighborhoods all surrounding transfer stations. So it was kind of interesting that the Attorney General thought, oh, well, this might not be a suitable location for children. And that was the language from the statute that she was hanging her hat on, so to speak. So one thought, if you are inclined to think about, you know, the spring town meeting or even the fall town meeting for possible changes, do we want to expand where multifamily would be allowed by right to something beyond industrial A and industrial B zones? Again, I'm not suggesting that you need to, but that might be one possibility. The other thing that the Attorney General also pointed out was that we didn't call for any sort of buffer between, say, the multifamily uses and other uses that might be allowed in the industrial zone.
Don't we have in that bylaw, we have additional setbacks for residential abutting commercial?
Right, right.
And, yeah, site plan would address that.
Right. So there's also a flag for site plan, which I'll mention in a moment, but I think the inference was, you know, when we look at marijuana, we have the statutory 500-foot buffer between a marijuana establishment and, like, you know, a school. We might want to consider, do we want something more substantial than just what we did. Again, we don't have to, but just, something to think about. And then when it came to site plan review, the Attorney General had sort of two cautions there. One is the generic reminder, and we see this in a lot of their decisions, so this wasn't something unique to Pembroke, but they always like to remind communities that site plan review for uses that are allowed by right, we don't have a lot of discretion. So in other words, we can't deny a site plan approval because we don't like the project if the underlying use is allowed by right in the zoning district. So there's that standard language that they throw into these decisions just to remind us, or you're cautioned to consult with town council, to make sure that we don't go off track and do something where we, by use of site plan, wind up unreasonably conditioning a multifamily that would be allowed by right, or essentially through site plan prohibiting the multifamily that is supposed to be allowed by right. That's something that can absolutely be addressed through the site plan approval process. I don't think that's anything you can really build into your bylaw. I think that's just something that, the board needs to be aware of when and if you're ever confronted with one of these projects. The other thing that the Attorney General flagged with respect to site plan approval is the provision in the bylaw that talks about being like an evaluation as to whether or not certain uses considers community needs. And I think the inference that the Attorney General was making, that we make an exception in site plan review for 1 and 2 family houses, but we don't make an exception for multifamily when it comes to considering whether or not, the use is consistent with community needs. I personally, I don't feel like that's a real concern, where you've taken affirmative steps to actually adopt the MBTA communities so that multifamily is going to be a use allowed by right. I find it hard to believe that a board is then going to go through site plan approval and say, oops, multifamily? No, sorry, we really, it's not consistent with, our master plan or something like that. I don't think that that's how anyone board would actually apply this. But it was something that was flagged, that maybe we could look at amending Section 7E1 so that we also include multifamily there the same way we include, we exempt 1 and 2 family residences. Maybe we also exempt multifamily. And maybe we simply exempt multifamily when that use is allowed by right, to make a distinction between, say, we're not making a blanket exemption for all multifamilies. There might be other types of multifamily, like, a cluster development, for example. But maybe here we add something here.
Wouldn't those be under special permit?
Yes, rather than site plan approval, yes. Fair point.
So
But I'm just saying there could be some other multifamily uses out there that might fall outside of the industrial A and B, where maybe site plan approval might be triggered.
Yeah, but then we'd have to amend the zoning bylaws for those other zones with the special permit provision for community needs consideration. I just don't think we need to do that.
I think, like as I said at the outset, I don't think you need to do anything, to be honest. But this one got an awful lot of scrutiny because, like I said, it was the first one of substance coming through. And I'm not suggesting that the AG was being picky, but I think she did want to be cautious and flag some things, because who knows what, this coming year is going to look like with all of the other MBTA community bylaws that I expect they'll be reviewing, so.
So, community needs is kind of a broad term. Like, what exactly does that mean?
So this is what the provision of the zoning bylaw was that was flagged in the Attorney General's letter, talking again about site plan approval and evaluating the project in a manner which considers community needs to include protection for abutting landowners, traffic safety and access, adequate waste disposal, drainage, parking, and environmental protection. That's That's everything, isn't it? I'm hard pressed to find one more thing that doesn't fall into one of those categories for you. So,
And we address all those in site plan.
right. Right. So,
So we don't really need to.
right. So at the end, I don't see where we really need to change anything because, if you've got a problem with respect to a multifamily, traffic, you're going to address it. Site circulation, parking, whatever it is, you're going to address it as part of your conditions. I don't think anyone is going to say, and at the end of the day, we're going to deny site plan approval for a multifamily because we think it's inconsistent with our community needs. I just don't think I think it's a stretch, is how I would put it.
Okay. Okay. I thought that would take us a lot more to get through there. I mean, any other,
No, I'm glad we don't have to, I mean, I would suggest that we don't.
yeah, because if
Do
we don't have to go
anything.
back to the
Yeah.
people
town,
in town.
Well, that's just it too. I mean, it's not easy to get these things through town meeting. I mean, I was there, I remember, Madam Chair, when you stood up, and there were a couple of people in the audience who were pushing back about this. If you've got it passed, and there's nothing fatally wrong with it, let it go. Let it go.
I
Okay.
agree.
We can
agree.
address the rest of it on an application by application basis, make sure we do the right thing. And who knows, maybe 2 or 3 years from now, we say, maybe we should tweak this, but by then, maybe we've grown accustomed to it, or we've already perhaps even seen our first project come through.
Do you foresee, I'm not asking you to look in the crystal ball, but do you see the Attorney General spotting something in somebody else's that is coming later and then coming back and saying, oh, we all have to change something, or?
She doesn't have the authority to do
Okay.
that
Okay.
necessarily, but I have seen instances where, like, we've seen this a lot, for example, in our world of solar, we feel like solar bylaws have been on a roller coaster lately. Yes, you can regulate them, no, you can't restrict them. Well, you can regulate them a little bit, but you can't regulate them that much. So it doesn't mean that if Pembroke passed this bylaw and it got approved as it was, it doesn't mean that if Norwell or Cohasset or somebody else does something this year and the Attorney General looks at that and says, that's some interesting language, and I think this is problematic. She doesn't have the authority to then go back and say, Pembroke, this is a problem for you. It would be something, though, that we would likely point out to you, that based on what we're starting to see, this could be a problem, where you could see a potential developer coming in with an application and saying, I know this is what the Pembroke bylaw says, but the Norwell bylaw that was passed 6 months later that the Attorney General reviewed, the Attorney General struck a very similar provision. I could see where we might need to be careful about how we address it in that context, and maybe think about amending something going forward. But with all due respect to the Attorney General's office, it's done, right. It's done, and it's now approved. Even in here where they talk about the fact that, our zoning bylaw prohibits landfills. And then she goes to great lengths to talk about state law where we can't possibly have allowed this, and perhaps the bylaw was adopted prior to 2005, blah, blah, blah. It's very nice of you to point out to us now that our bylaw may not be enforceable today because of that provision, but it doesn't change the bylaw itself. We would just have to be careful if someone came in with a particular project, we got to make sure we do follow all of the advice.
So I think we're good on that
It's
one.
not broken, don't fix it.
Yeah, exactly.
I couldn't have said it better, yes. Or at least it's not broke yet, so don't fix it yet.
Right.
But I'm happy to answer any questions if anybody else has
Andy,
anything.
did we have a question about ADUs coming? No? Okay. I thought there was something before with the MBTA that they also were joining it with the ADUs, but I don't think it all went through, but we didn't address it yet. So
Okay.
I just wanted to know if there
And
was something that we needed to coming soon.
No, it was all part of like the same housing choice legislation that included references to ADUs as well. The governor, I think in October, filed a bill that is still pending with the legislature that would allow ADUs by right, I believe, in at least one residential zoning district. And there are, a couple of other things in that. I just had another community that was considering amending their ADU bylaw, last week, and they decided, why bother? Let's wait and see what happens with the legislature, because we don't want to expend some capital, selling this to town meeting only to have the legislature go in a very different direction, and then we have to, strike our bylaw or revise it. So that's probably sound advice right now, to just sort of wait and see what.
Well, we allow ADUs pretty much everywhere for residential, so, right, there's not really a zone we
Well, yeah,
don't.
but it's the in-law ADU.
The in-law ADU.
And it's attached.
Right.
Not detached. So there's some distinctions there.
Right. The legislature was being a little more, even with housing choice, they made distinctions between attached versus detached ADUs. So, who knows? I wouldn't be surprised if we see some relaxation on that.
Doesn't the town's zoning bylaws supersede any legislative action?
No, they don't. So our zoning bylaws cannot be inconsistent with state law. So while we could argue that if we have an ADU right now that only allows attached ADUs, and let's say the ultimate legislation would compel detached ADUs to also be, a use allowed by right, we'd now have a bylaw that's inconsistent with state law. Again, it doesn't repeal our bylaw, but we would have to be careful that if someone came in with a detached ADU application and we were going to take a real hard stance and say, but our bylaw doesn't allow it, the applicant's going to say, well, state law has now superseded that. So we would then have to have a conversation about where to go with this.
Okay.
Better to change the bylaw and still be able to regulate and have some control than to simply say, well, the legislature took this out of our hands, we can't do anything about it.
Well, sounds like they're doing that, though.
They are,
It's
they
gone
are.
up
They're
for-
trying,
in a
they're
bill
at least
a couple
trying.
times and
Yeah.
not made it through. Taking, being detached or detached, because I keep watching them and they don't make it through, and then somebody else puts it through like a year later.
Right.
Eventually, I'm
Ma-
sure it'll
Maybe
go
they
through.
think, eventually it gets passed, eventually people get worn down, but it hasn't happened yet, so we'll see.
Okay,
All right?
great.
Well, thank you
so
very much and Happy New Year, folks.
Happy New Year. Thank you for coming in and helping us out with that.
No problem.
All right.
Sorry if I put you ahead of schedule.
It's okay.
No, that's great.
All right, so our next item, do we have a person here for that? Because it's not,
If not, if the folks are here for the next one, we could start
Right.
with that.
Or we can pass our minutes.
okay.
Are they outside?
Are you here for the medical center?
No, for Dave and Russ,
Lily's Way?
yeah, conceptual plan for Lily's Way.
Excellent. Okay. Well, we do have a couple administrative matters while we're waiting, if anybody, we have to extend the site plan approval. Nope. Okay. Okay.
So I can make a motion to approve the minutes of December 18th.
Okay, so we have a motion on the table to accept the minutes from December 18th. Do I have a second? Okay, all in favor? Oh, wait, I'm sorry, I forgot, we have to do roll call. Roll call, Jim? Andy? Heather? Dan?
Aye.
Scott? And myself, aye. So moved. We've accepted the minutes for just
first?
Dan.
Oh, me,
and who was second?
Scott.
Thank you.
Sorry.
Sorry, we're just taking up our time here. Okay, so now we have, this is for the Lily's Way, correct? So we have a discussion about a new possible subdivision of Lily's Way and Red Barn Road. So if we have somebody like to come up and start the discussion, tell us who you are and so on and so forth. Anybody else?
Dave West, my wife Kim, and Steve Lake from Grady Consulting. So I was here maybe 6 months ago, and talking about possible uses of land off of Lily's Way and behind us on Barker Street. And since that time, we hired Grady Consulting to take a look at what the possibilities may be. And the first thing we did was the wetlands, determining where the wetlands were, and getting those flagged and put on a drawing. And it turns out the wetlands were different than what we anticipated initially. So with that being said, I think there's just room for perhaps one house lot there from coming off of Lily's Way. So Grady Consulting took a look at it and drew up this concept drawing. That,
And so you'd be with this one house lot outside of the 100-foot buffer zone, so you wouldn't need Concom approval?
Can I stand up?
Yeah,
with you?
please
I
do.
wasn't sure, I wasn't sure where this was gonna go. My name is Steve Lake, Grady Consulting. I actually did the survey and drew the plan for David. So yes, the one house lot would, in the house where you show where I show the 150-foot circle is well outside the 100-foot buffer. Be no need for conservation.
And then the frontage that you'd be getting on the site would be in that extra circle that you've taken off of Red Barn Road.
Correct.
And that would give you the 150-foot of frontage required
That is correct.
for a single-family
Exactly.
housing lot. Okay. And then you weren't proposing to build that circle, you were using that just for frontage.
Exactly.
And then you were proposing to put the hammerhead driveway in to satisfy the fire department.
Yeah, for apparatus to be able to get in and get out. Yes, we were asking to waive the construction of the road itself
Okay.
and put the gravel driveway in, correct.
So this is an extension of the existing subdivision,
Yes, it is.
and it's one house.
Lily's Way is accepted. It's an accepted road, so it's not a private road.
Right. And it's well within the 1,000-foot rule for subdivision.
That is correct.
So is it Red Barn Road or Lily? I'm so confused.
Lily's Way,
Oh, that'll be Lily's Way.
The subdivision is.
Actually, the subdivision is Lily's Way. That is my error on that plan.
Okay.
It's actually Lily's Way, and it's shown on a few subdivision plans as Red Bond and as Heritage. Red Bond would be the one off of Barker, Lily's Way would be the T.
So you'd be looking for the approval of a Form A lot on this once you?
Yes.
And from us, you're just wanting to know if this is okay, what other requirements you would maybe need?
Exactly, what, any other thing that you would like to put on as a requirement, and then we would perform the additional surveying and prepare the Form A lot
Okay.
plan.
Jim, did you have any comments on this?
It still constitutes a subdivision, but probably a limited subdivision. It's not just a straight Form A,
Okay.
but definitely a limited subdivision, and I'm not even sure if they need the hammerhead and stuff there. To me, there's a hydrant right there at the end of the new driveway. As long as the fire department's happy, I would be quite happy with just a regular driveway going into that new house.
Yeah, as long as the fire department signs off on it. Yeah.
But what would be a limited subdivision to go through then?
Did you hear that question, Jim?
I believe we've lesser fees for a limited subdivision.
That's
Like
what?
1 or 2 lots.
Oh, okay.
Lesser fees?
Yeah, at one time we did. I'm not sure if we've ever changed that or not.
I don't remember
But
ever
we
seeing
did have a procedure where a limited subdivision was.
Okay.
So it would be a limited subdivision rather than A and R.
Hey, yeah, it could be. I'm not 100% sure of that, but,
That does make sense now that he mentions that.
Yeah.
Rather than A and R, that would be, it makes sense.
yeah.
It doesn't make sense to me, but if it makes sense to you.
Yeah, I mean, if it works, it's gonna work either way.
It will,
Yeah.
it will. I mean,
Yeah,
Once
and,
we
I
prepare the
mean,
plan.
there's really no reason not to agree to this.
Yeah,
Right, okay.
yeah. I don't see anything wrong with it at all, so we just need to, I think you could move forward with filing the limited
The
subdivision,
formal
and
application, okay.
Yeah.
Excellent.
I think you're good to go.
Okay, great.
And we'll have a
Awesome.
Thank you
You'll
very
still
much.
have a public hearing, correct? For the abutters, or no? For a limited subdivision? I'm not sure what a limited subdivision entails, so.
Yes, okay, so Jim's confirming, yeah, we'd have a, yeah, you present the limited
Okay.
subdivision to us in a public hearing.
Sure, that's
Okay.
fine.
What about the fees?
Excuse me?
The fees?
I'm not sure what the fees are
Okay.
surrounding it, but
Would be less than,
What-
you guys will know what.
We will do, yeah, we will do,
Yeah.
yeah. I'll do the research on that and then make sure, yeah.
And then we probably have a very limited engineering review, peer review.
Okay. Limited?
It's not a huge subdivision, it's just a.
No, it's, yeah, one lot.
It's
so-
one
yeah.
lot.
one lot.
Well, it's actually a re-subdivision of the abutting plan. So, I mean, that could be considered a limited subdivision also, but there is an existing subdivision showing the 4 lots off of Barker. Now we want to access it off of Lily's Way.
Okay,
It's just showing new access. Interesting, it's an interesting concept, I mean,
yeah. Any plans to do access off of Barker Street?
no.
Yeah,
No.
it's, I think the wetlands.
The wetlands probably
Okay.
precludes that.
Gotcha.
Restrict that.
All right. Yeah, so proceed with a limited subdivision. Work with Sue and we can get a public hearing done and get you on your way.
Yeah,
Okay, great,
okay. I guess
excellent.
that's it.
Great, thank you very much.
Yeah, thank you for your time.
Thank you. Coming in. I feel like I should have brought my easy button that I got for Christmas. All right, do we have anyone here for the medical center? Okay, come on in. All right. Now, discussion about possible new medical center at 482 Center Street. Who do we have here for that this evening? If you come on up and tell us who you are and if you live in town and your address, or, I'm just kidding. Your social security number? No, I'm just kidding. Everything. What's your blood type? No, just kidding.
My name's Samantha Montigny. And this is my husband, Chris, and this is my father, who actually owns the property that we'll be leasing.
All right. So tell us what you are proposing
gonna
and
put this
what
down.
you'd like to discuss with us.
So, the facility actually operated as a daycare before, so it is already business zoned, and we're just looking to repurpose the business space and make it into a medical clinic at this point. I'm a nurse practitioner, and I'm opening my own practice, so the goal is to establish my practice within there.
It's not business zone,
It's not?
it's residence ed.
Oh, really?
Well, 'cause we had a daycare.
They had a daycare in it
for
before.
20 years.
Yeah.
It's residence ed.
Oh,
I mean,
That means, per the bylaw, you can't run a business out of there.
oh, okay. That's news to me. It had a business in it before for 20 years, so that's why I was under the impression that we could do that.
As per the bylaw, now, a sole proprietor maybe, as a, like a dentist or a physician who is a sole proprietor, there is provisions for that in Residence A,
Okay.
as per the bylaw.
okay, but there was a daycare that was running there. Okay, I'll come in. There was a daycare run there, when I bought it,
Okay,
okay? and it wasn't the people that live there that ran the
Well, that-
daycare. And then my wife took over and ran the daycare for 20 years. And it was not because it was resident-owned.
Yeah. but that
'Cause I-
does- but-
Because I bought,
Zone residential.
it's
I know,
zoned-
but what I'm saying is just saying it was zoned that way, but I bought the building with a daycare in
In
it.
it,
Right, right.
yeah.
Okay, the residence was upstairs, and it was a separate business, somebody else ran the business. I bought the business, then I went to find out who owned the property, because I said, I don't want to own a property, buy a business, and then somebody, a year from now, say, oh, we don't have a lease here anymore. So I bought the house from the homeowner. Right, so we ran a business there for a long time.
Right, right, but it's not zoned for that.
So how did we get away with it?
Yeah, how
How
did
did-
that
how
happen
did-
initially?
how
I
did
guess,
it
yeah,
happen?
how did it happen
How did it
initially,
happen
right, yeah.
initially?
Yeah,
What is it?
So what do we need to do?
Center Street is residential A?
No,
So I mean,
but that portion of Center Street is Residence A.
no,
Oh,
it's
it
not.
is? Okay.
Across the street there's a business?
It's all Residence A.
Okay.
It may not be a legal business, but it's Residence A.
We had a sign out front and everything. The house across the street has a sign out front.
Just telling you what the zoning is.
I know it, I'm just confused, that's
Yeah.
all. So what can we do to change that?
Change the zoning bylaw.
Gotta change the zoning bylaw.
I mean, there are uses allowed by special permit for trade occupations such as electrician, radio, TV repair, plumbing and carpentry, or other similar occupations. Again, the sole proprietor who may have a business for repair, right? All of those are subject to provisions of paragraphs A, which includes the uses allowed: a detached one-family house, a church, municipal or civic use, a farm, garden, nursery, or greenhouse, which may sell produce, the major portion of which is raised on the premises, but excluding any use which is injurious or offensive to the neighborhood. Home occupation, again, like a sole proprietor, classified as follows: the office of a physician, dentist, lawyer, architect, accountant, or bookkeeper. You may fall under that. Right?
Okay?
Medical center doesn't necessarily, you think about medical center as, 3 or 4 doctors in a practice.
That's not
no,
gonna be the
it's not,
case.
that's not the
It's
case.
not
It would
the
be
case.
me individually.
Okay, so, per the bylaw, that use is allowed. It's a home occupation use. However, the operator thereof resides thereon,
Okay,
and the space occupied by such professional or business use shall not occupy more than 25% of the total floor area of the dwelling, exclusive of the basement, whether said space is located in the basement or elsewhere. And parking will be limited to 3 motor vehicles for customers and clients. No person may work therein who is not a resident of the premises.
okay. And in that case, it sounds like it's not feasible.
Okay, but I'm still confused.
Well,
No, because
yeah.
you're saying, but we had this office, not, the building department used to come and
And
inspect.
license it, yeah.
And inspect the property, give us the permit to operate from this office, from this building.
Yeah,
Yeah.
sure they did.
But it wasn't,
Allowed.
right, so the building department didn't know that?
Didn't get a complaint. I don't know what to say.
Would have been existing non-conforming at the time, but has it been turned back to a
Our
residential?
zoning
since?
goes back to 1971, so it's probably,
Nope. It was built in 93.
okay.
Okay.
So as per the bylaws, it's not allowed.
Okay,
Okay?
all right, thank you very much. All right, you guys
And,
have,
you can talk to the zoning enforcement officer if you want some clarity on that. I can't.
I understand it, I understand what you're saying.
Yeah,
I don't need any more
I'm just
clarity.
confused.
Yeah,
and-
just
and I
confused
don't
how a
blame you.
business
Yeah, I
ran
mean,
for
You've had something going there for a
20
while.
years, and then, well, prior to that, there was another business in there, so I totally understand his confusion for sure.
Yeah,
Because I bought
Yeah.
the business.
I do too. I totally understand that.
Then I had to buy the house, so
Yeah,
I bought the business separate from the house,
Yeah,
and then I bought the house.
And this is typically what happens with something like this, is a new use comes in and then boom, we find out.
Now it's kind of shed some light on it. Okay, the business closed down and now this kind of brought it. Okay.
Right.
Mm-hmm, makes sense.
Yeah.
We could move in for a few months and then you live there.
I used to live there.
Yeah,
But if you want, you can, and the bylaws are on the website,
Okay.
but you can take this.
Okay, that'd
Okay,
be great.
just so you
Thank
have
you.
it.
Yeah, thank you.
And the complete text is on the website, and if you want to talk to the building inspector or the zoning enforcement inspector and question him about that,
Okay, yeah,
Feel-
it's
feel free to-
finished, but the building inspector used to come to my house.
I get
Yeah,
it.
it makes, yeah.
The fire department used to come to my house, I have, it's wired for,
Yeah.
smoke alarms,
Yeah.
fire panel.
I know,
all
we
that
just
stuff.
went through the whole re-licensing process.
Yeah, okay,
All right. Well, back to the drawing board we go.
thank you.
Thank you. Have a nice night.
Have a nice night, thank you.
There's no, like, holes in the zoning down that way? Okay.
I just don't know which.
I mean, there may be
How
some
far
sort
down
of
that is.
provision that it was allowed somehow, but it would be good to find out from the building department if that was so.
It's like set back, the house is really far back.
Yeah, but the Residence A goes to the rear of the lot.
Three, yeah.
Interesting.
Yeah.
Zoning enforcement hard at work.
Well, it may have been there for a long time. They sold the business. They didn't, it never came up as an issue. They never had to come to anyone for a site plan where,
Right, well, it probably just was, the
Yeah.
business just kept rolling to different people, and they were just like,
yeah. And there could be any number of similar examples out there.
it could have even started well before 71.
Yeah.
I'm just surprised that they have the fire system in there, and that alone, I would think that
Yeah, well, the fire
Trigger
department
something.
has to inspect it for their certificate of occupancy every year.
Yeah.
And they have to renew it. So,
So maybe
But-
there should be like a trigger of allowed use?
yeah,
when-
but that's what this is. You know, they're changing the use, so they come to us for guidance and we have to tell them what the rules are.
So it's a just straight residential right now? The
Well, they-
building,
they-
or is there a
Residential.
business?
Well, it seems like they're using it for, well, they had been using it for a daycare. And somebody lives up there too. I mean, I think there's a residence there.
Interesting. Okay.
Well, you know, the other daycare that's in the center of town on Center Street is in Business A, I think.
Yeah,
Or
yeah.
part of the center protection, or residential, center protection district.
Right, so the Center Protection District
Allows it.
but, okay. All right. Okay. So now we have a discussion and possible vote on extending site plan approval expiration date of, approval expiration date to June 21st, 2025, and to complete project in its entirety to June 21st, 2026 for site plan SP2-21 at 715 Washington Street, contractors units. Let's see.
Well, they do have a memo in here.
Yeah,
with
they do have the
extension
the
request.
extension request.
And it appe- Yeah, well, it does appear that they had an appeal of the zoning variance that they received from the ZBA and the order of conditions. And those were resolved in favor of the applicant. So I see no reason why we shouldn't
yeah.
extend it.
Yeah, I'll make a motion to extend site plan SP 2-21. 715 Washington Street until,
So they were asking for a year and a half extension.
Yeah,
February.
We're asking for 2 years from when they.
and they
filed the
have
doc.
3 years to execute the site plan.
Right.
okay,
Because
so
of all
I
the variances,
I will-
That's why they extended the time.
it's okay,
from
okay,
April to June.
gotcha. So I'll make a motion that we extend the the extensions until June 21st, 2025 for the permit's expiration, and June 21st, 2026 for the completion of the project in its entirety.
Second.
Okay. Roll call votes. Jim? Andy?
Aye.
Heather?
Yes.
Dan?
Aye.
Scott? And myself, Alicia? Yes. So moved. So we'll grant them that extension. Alrighty. Okay, and then we have some routine matters here. We've already done our vote. For the minutes. We have another vote on here,
See,
SP 19.
Yeah, that's for 171 Matakeesis Street. They applied to the ZBA for a special permit for outdoor display of goods while they're finishing up the project, and now they're asking for an extension.
Yes, because we gave it to them till January
Yep.
of '24.
Okay, so they're asking for an extension to November 5th, 2024, and a completion of the
Yes.
project in its entirety to November 5th, 2025.
Yeah, so I'll
Yes.
make a motion that we extend the site plan approval expiration for 171 Matakeesis Street, site plan SP 2-19 to September 5th, 2024.
Okay? Do I have a second?
a second.
Okay, roll call. Jim? Andy?
Aye.
Heather?
Yes.
Dan?
Yes.
Scott?
Yes.
And myself, yes. So moved. Are there any other routine matters that we need to discuss this evening?
The annual report,
Oh, yes.
everybody had a chance to look at that?
Nicely done.
Hey, this is the first time we've ever seen one before it was printed.
I
Hey,
wasn't sure what the protocol was.
Oh, no,
Matthew
it's
sent it to
great.
me last time,
Oh, did he?
but it was a lot longer.
Oh, it was sent to the chair. Well, it comes from you, so
Yeah.
if you think it's okay, I'm with you.
Looks fine.
Looks, I've only read one other one, so look good to everybody?
Yeah?
Anything we should add or take away? We're good? All right. Looks good. Anything else?
No, that's it. We still have 715 Washington Street coming.
Oh,
Do you have their number?
Just tell
Call them.
them.
Yeah, I'll go upstairs and see if I can find it. So technically, for anything like that, for an extension, we don't need the applicant here?
I think they wanted to come in and explain the situation because of the appeal,
Okay,
but I think they did a pretty good job explaining it to us
okay,
this way.
Yeah.
okay,
And I don't see any reason not to extend it for them.
okay,
They wanted to be extended because they were tied up so long.
Yeah,
Yeah,
yeah.
yeah,
They were tied up for the whole period.
yeah.
yeah.
Yeah. And most often when people are asking for the extension, they're already like midway through the project, so we usually it's like, no, you have to stop now. No, we let them, so they don't always have to come in, but in this situation, if they hadn't written such a, we
And-
might want it to have talked to
And I'm
them.
familiar with that project. I'm
yeah.
sure those of you who were on the board when we saw it,
Yeah.
so,
Okay, great.
Okay, do I have another motion, anyone?
yeah, motion to adjourn.
Do I have a
Second.
Okay, roll call vote. Jim? Andy?
Aye.
Heather?
Yes.
Dan?
Yes.
Scott?
Yes.
Myself, yes. Adjourned.
Beautiful.
Thanks, Jim. Okay, bye.